ang natira, medium period. Pag may natirang mitigating circumstance, minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period, pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang epekto, maximum period. Offset rule, i-offset mo muna. Tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, section.
You have to be guided by Section 1 of Rule 138 because Rule 138 is one of the sources of legal ethics. Who may practice law? Ang sinasabi dyan ay any person heretofore duly admitted as a member of the bar or hereafter admitted as such in accordance with the provisions of this rule and who is in good and regular standing is entitled to practice law. Iyan po iyon. That is ULEP versus Legal Aid Clinic. ULEP versus Legal Aid Clinic. Okay? Yan yung doktrina. Alin yun, sir? Yung any person. Kasi any person may mean na pwede palang mag-practice. Kung hindi yan natin makokorek, pwede palang mag-practice ang juridical person. So let us disabuse.
The shares of XYZ, the 40% shares of XYZ, likewise owned by the same foreign corporation owned by foreigners that directly owns 40% of ABC Corporation. So to repeat, let's say the foreigners, right? The foreign held corporation owns 40,000 of 100,000. At the same time, the foreign held corporation owns 40% of XYZ share in ABC Corporation. So the question now is, based on these figures, is ABC a Philippine national? Is it qualified to invest in public utility? Is it compliant with the Constitution?
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply, under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are been controverted already. So maski walang reply, all matters raised in the answer are being controverted already. If you talk
in relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay, but in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together we can.
Walang natira video video. Pag may natirang mitigating circumstance minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period, pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang ang epekto, maximum period. Offset rule, i-offset mo muna, tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, exception.
To our dear attendees from different parts of the country, I pray that you're all in great state of health. This free webinar is streaming live via the VLC Law Center's YouTube channel and Facebook page. If you can hear my voice clearly, please type in the comment section #VLC. Thank you. Yes, thank you. Optimize this learning opportunity. Share this free online lecture to your friends and together learn at the comfort of your homes. I want to formally welcome you all to this free webinar. This is part of a series of free online lectures brought to you by the Virtual Law Companion of VLC's Law Center. Allow me to share to you this good news. The Virtual Law Companion is the newest innovation of VLC's Law Center, which aims to provide an easy, convenient, and quality bar review experience. The Virtual Law Companion is a web application that is hosted on a dedicated cloud server. It can be accessed via the internet 24/7 through any web browser, using any device or handheld computers like Android or iOS phones. Meaning, you can study anytime, anywhere, and from any mobile device. Please visit our website at www.vlcslawcenter.com to know more about our programs and activities. Before we formally start, please take note of some reminders. First, this free webinar is pre-recorded to ensure the uninterrupted streaming of lectures. Secondly, VLC team will be with you to assist you should you need more information about our program. Please visit and subscribe to our YouTube channel and Facebook page. Without further ado, please give your virtual class and welcome our lecturer today. Again, this free webinar is brought to you by our Virtual Law Companion. Maraming salamat po. Together, we can make things happen. Together, we can.
Good day, everyone. I am Professor Jedrick Nang. I am connected with the Department of Justice, and I'm also a law professor in various schools here in Metro Manila. Welcome, everyone, to this free online lecture brought to you by Virtual Law Companion of VLC's Law Center. Okay, prepare for the bar anywhere, anytime, and check out the VLC website at www.vlcslawcenter.com for more details. Now, before we start, please comment VLC if you can hear me clearly. All right. So for today's lecture, I will be discussing updated anti-graft laws and jurisprudence. So I will be covering first Republic Act 11032, then some special laws, then latest jurisprudence on anti-corruption laws. All right, everyone. So we'll be starting my lecture. So updated anti-graft laws and jurisprudence. Okay, I'll start with our Republic Act 11032, or this is what we call the Ease of Doing Business and Efficient Government Service Delivery Act, or what we call the amended anti-red tape law. Okay, so let us discuss the salient features of this law. Okay, first, what government agencies are covered by RA 11032. Now, the law mentions that this rule shall apply to all government offices and agencies in the executive department, but it includes local government units, so LGUs, municipalities, cities, also covers government-owned or controlled corporations and other government instrumentalities located in the Philippines or even abroad. Okay? So even these government agencies that provide services covering business-related and even non-business transactions. So if you look at the definition, the coverage of what we call EOD below is quite broad and extensive. No? It covers all government agencies. Di ba? Because it includes all government GOCCs, LGUs, and all government agencies, instrumentalities that provide business-related, even non-business transactions. So, in short, almost all government agencies and instrumentalities are covered, and they should comply with the EOD below. Okay. Now, one of the features of this law is the law mentions or defines what is the prescribed processing time for government services to be rendered. Okay, for applicants who are applying for government certificates, licenses, permits, and all others. So, what is the time provided by the law? So, the EOD below provides what we call the 3-7-20 rule. Okay? So, only 3 days for what we call simple transactions, 7 for complex, and 20 for highly technical transactions. Right? So, 3 days simple transaction means it does not require any evaluation, just submission of requirements and payment of the required fees. Okay, if all the requirements are submitted and the fees are already paid, then the period now will run. No? Dapat 3 days lang for simple transactions. Example of that are business permits from LGUs. So it's considered a simple transaction. It's a matter of completing, submitting your requirements, and paying the necessary fees. No? So it should be 3 days only. Now, complex transaction requires evaluation. No? Okay, submission of requirements should be evaluated. No, so it will take 7 working days. So this pertains to working days. No, 3-7-20. Okay, and then highly technical transactions. Of course, it requires more extensive evaluation, which requires technical expertise. No? Kailangan pag-aralan, evaluate, and be studied further. Okay, so these highly technical transactions should be done at least 20 days. So the 3-7-20 rule. So yan yung deadline for government agencies to act upon their backlog and their services. Okay. Now, can this processing time be extended? Okay. So the maximum time prescribed may be extended only once, no? For the same number of days indicated in the agency citizens charter. All right, but there are requirements we follow. So there are notice to notify the applicant, should be in writing. Notice shall indicate the reason for the extension and the final date of release of the government service requested. Then the notification must be sent prior to the lapse of the processing time. Then the notice must be signed by the applicant or requesting party to serve as proof of notice. Okay, only once ang extension. Same number of days. Like for example, if it's a highly technical transaction, then the extension should be only for another 20 days. How about if there are periods provided under special laws to comply? No? There are some government agencies that under the law, which requires a longer processing time, no, for their services. So the law provides that if the government agency or office allowed to observe a processing time longer, no, than 3-7-20 working days, if there's a special law mandating a processing time for the delivery of that particular service. Okay. So for example, like in the FDA, no, They require, I think, 60 days is their processing time, no, under the law. So the 60-day period will be observed, no, to for them to render their services. Okay, but after that time that is mentioned under special law, if the agency fails to comply with that, then it's already also considered violation of EODB law. All right. So if there is no special law mentioning the prescribed processing time, then we follow the EOD below, the 3720 rule. Right? Sige. Another exception dito sa 3720 rule is what if there are actions needed from the local, the sanggunian, no? Okay? So if the application or request for license, clearance, permit, certification, or authorization shall require the approval of the local sanggunian, bayan, panlungsod, or panlalawigan, as the case may be, the sanggunian will be given 45 working days. Medyo it's a bit longer. Okay, it requires an action from the local council and extendable for another 20 working days. So 45 plus 20. No? Okay, it requires the sanggunian approval. All right. The EOD below also mentions the limitation of signatories. Okay, for the number of signatories in any document, a government office shall be limited to a maximum of only three signatures, no, of officers directly supervising the office or agency concerned. Hindi na pwedeng marami yung signatories, like you're waiting for 10 to 15 signatories because it would take no, a long time, no, for the document to be released. So three signatory rule lang. Okay. So in case the outer signatory is on official business or leave, an alternate shall be designated. No? And the law also mentions that e-signatures, no, or pre-signed license, clearance, permit, certification, authorization with adequate security and control mechanism may be used. So I think this is currently used, especially during previously when we're in a pandemic, no, that e-signatures were already allowed in government documents. Right? Then we look at the Citizens Charter. No? So what's this Citizens Charter? So EODB law states that the Citizens Charter, no, is saying that all government agencies must have the Citizens Charter. So this is where, what's the contents of this? No? Actually, the Citizens Charter is an official document. No? It should communicate to the public. No? What are the services or standards on services provided to citizens? No? And the step-by-step procedure for availing such a service, the responsible person, the documents needed to be submitted, fees to be paid, if any. Like for example, if you're applying for a license, no, or a driver's license, so how long? What's the step-by-step procedure for that? What are the requirements to be submitted? Who is responsible for that? How much should be paid? No? Okay, this is important because later we discuss the violations under the law. So the procedure and the fees should be clearly stated, no, in the Citizens Charter. Otherwise, it will constitute a violation of the law. Right? So all government agencies should have this charter, must be an updated one. Hindi na pwede yung luma na, no? Okay? And then, what is the format for this Citizens Charter? It could be in a billboard, okay? Or is it posted? Typically in the main entrance of the office, no? Or the most conspicuous place. Meron na rin requirement under the law that it must be in the government websites, no? And also published in either in English, Filipino, or in the local dialect. Okay? So it has dual purpose, establishing accountability and recognizing good performance of the government agencies. So again, this is very important kasi ito yung basehan ng services of a government agency and the fees and the requirements, no, that are needed to avail of their services. Right? Then, EODB law mentions this zero contact policy. No? Okay, zero contact, right? So, I think for us who during that time of pandemic, diba, dapat zero contact, no, for health reasons and all. But the law already mentions, no, that government transactions should, no, government agencies should adopt what we call a zero contact policy as much as possible. Okay, this of course envisioned to prevent, diba, situations of corruption dahil no interaction, no, between the applicant and the government official. Okay, but the law mentions that interactions are necessary. Okay, um, for a to contact, no, to be with to see an actual government official. Pero hindi naman ganung transactions, no, like payments of application and fees, and also those are complex or highly technical transactions. As I said, it requires further evaluation. Okay, basta it should be recorded with consent and it's documented, no, yung interactions, no. Okay, notice of meetings, the minutes, the attendance, okay, must be recorded. Right? Otherwise, dapat zero contact policy. Right? Now, who would be held accountable, no, or liable if there is a violation of the EODB law? So the law states that it is the head, actually, the head of the office or agency shall be primarily responsible for the implementation of the act, including these and other rules and regulations, and shall be held accountable to the public in rendering fast, efficient, convenient, and reliable service. Okay? So head of office, no? Because all transactions and processes are deemed to have been made with the permission or clearance from the highest authority, having jurisdiction over the government office or agency concerned. Right? It's sort of one responsibility, head of office, no? Towards also subordinates. Okay. Then, what are the penalties, no, for violating the EODB law? Okay. So there's a two-strike policy here. The first offense is an administrative liability with 6 months suspension, except for cases of fixing or collusion. Okay? Pag yung kaso ay fixing or collusion, diretso na yan dun sa second offense. No? Okay? For the second offense, dismissal from service, disqualification from holding public office, or future retirement benefits and imprisonment of 1 year to 6 years. So, in a fine of 500,000 pesos to 2 million pesos. Okay, that is a two-strike policy under the law. Okay, so first, admin liability lang. Then, second offense, meron ng criminal liability, no? May imprisonment, okay, and a fine. Okay? But if it's fixing again, relating to fixing, ano na yan, it's considered as the second offense. Meron ng criminal liability. Right? So let's look at the violations, no, under the EODB law. So this is in section 21 of the said law. Okay, so what are the stated violations here? No? So these are the enumerated violations. So first, the refusal to accept an application. No reason, no unreasonable refusal, no, to accept any application from the public. All right. Letter B, additional requirements, no, not in the city's charter. So if you look at letter B and C, the additional costs in the city's charter, so they are related to what I mentioned a while ago. In the citizen's charter, so all the requirements and fees should be stated already. Okay. If the government agency asks for additional requirements and additional costs, no, that are not stated in their charter, then it's a violation of the EODB law, specifically here in paragraphs B and C. No? All right. Then letter D mentions failure to give the written notice on a disapproval. So what is this? No? If an application is disapproved by the government office, the office must give a written notice to the applicant on the disapproval. Kung bakit, diba, na-disapprove yung application. So that the applicant can resubmit or comply, no? Comply with the application. So anong sinasabi dito? No? Ibig sabihin dito sa letter D, So, hindi pwedeng ma-pending yung applications, no? Hindi pwedeng matenga sa government office, di ba? So, that is red tape. Pero, so, if the government office disapproves a application transaction, it must give a written notice of approval. Hindi pwedeng patagalin lang, no? Okay, so that is the rationale here of this provision. Right? Then, letter E, okay, as I discussed this a while ago, yung failure to render government services within the prescribed closing time. So again, remember the 3-7-20 rule. Okay, a violation of that, no? The applicant, any citizen, can file a complaint, no, against the government official involved. Okay, so compliance dapat doon sa 3-7-20 rule or the crossing time as prescribed by special law. Okay? Then letter F, failure to attend to applicants prior to the end of working hours and during lunch break. No? So, as you know, you can see if you go to a government office, no lunch break policy. That is under the old anti-red tape law already, as I mentioned there. Okay, and the government officials must attend to all applicants before end of office hours. Okay. Then letter G mentions failure or refusal to issue official receipts. Okay. Then lastly, we have this fixing or collusion with fixers. So I think everyone is quite knowledgeable about the concept of fixing, fixers. You mean to say someone who would obtain any gain or profit to facilitate government services. Okay, so it's fixers. So this law explicitly prohibits such fixing. Hindi pwedeng gawing career yung fixing because it is against the law. All right? The previous president's vision there is dapat government service must be efficient. No? And there is no need to go to fixers, right? To avail of government services. Okay? So these are the violations mentioned under RA 11032. Plus, yung last provision and violation is yung sa Bureau of Fire Protection. It explicitly mentions that its officials, employees shall not sell, offer to sell, or recommend specific brands of fire extinguishers and other fire safety equipment to any applicant or requesting party or business entity. Then there's a violation. A violation is penalty of imprisonment 1 year to 6 years, penalty of not less than 500,000, but not more than 2 million pesos. Okay? So, I covered the salient provisions of 11032. Okay? I hope the listeners, you have learned something from a discussion of the ease of doing business law. All right. So if you have any learnings and takeaways, you can just type them in the comment section. Right. Right. Now, for the second part of my lecture, I will go through anti-graft laws, some special laws on this. Okay, let's start with RA 3019 or the Anti-Graft and Corrupt Practices Act. So, the law already defines or punishes several acts relating to graft corruption. But I like to point out here, the most important feature of this law is this violation of RA 3019. It shall be in addition to acts or omissions of public officers already penalized by existing laws. Okay? So, for example, if a person committed bribery, direct bribery in violation of the RPC, it may likewise be charged under 3019 for the same act of bribery. So, in dalawang kaso yan, mga public officers. Pwedeng direct bribery under RPC and also violation of RA 3019. So usually, dalawang offender is punished under RPC and 3019. Okay? Now, let's also cover RA 6713. So this is the Code of Conduct and Ethical Standards for Public Officials and Employees. Okay, so the law mentions the norms of conduct of public officials and employees. So there should be commitment to public interest. So putting public interest first. Then professionalism, doing work with highest degree of excellence. Justness and sincerity, being true to the people all time. Political neutrality, okay, doing job with fairness to everyone. No, that's important. Okay. Then responsiveness to the public, being open to the public, providing the information that they want, and enabling the public to participate in decision making by public hearings, consultation. Then nationalism and patriotism, being loyal to the Republic of Philippines, promoting the Philippines in all aspects, commitment to democracy, and also simple living. Okay, mean to say the mode of living must be proportional to the income and position of a public official and employees. So these are the norms of conduct for all public employees. No? Okay. And also importantly stated the law is the submission, di ba, of what we call the statement of assets and liabilities, SALN. No? Okay. So it's submitted by public official employees stating their properties, assets, income, business of their wife, husband, and their children under 18 years old. Okay. 6713 also expressly prohibits because solicitation, no, by the government employees, solicit of funds or anything, no? So that's disallowed. And also the law states that this allows engaging of public officers in unauthorized practice of profession. No? So, moonlighting is prohibited, no, when one is in the government or public service. Okay. So there's also what we call the lifestyle check, no, and the filing of the SALN. No? So ano ba yung basis again of lifestyle check and filing a SALN? Because the consti itself, no, states that public officers lead modest lives. No? Okay, simple living. So public officials, employees, their families shall lead their modest life appropriate to their position and income. They shall not indulge in extravagant or ostentatious display of wealth in any form. Okay. Then the filing of SALN, okay, is required under the Constitution also for all public officials, employees. So whether it's regular, under temporary status, okay, it was filed this SALN. So in cases of the President, the Vice President, the Cabinet members, Congress, Supreme Court, Constitutional Commissions, and other constitutional offices, the officers of the Armed Forces, in general or flag rank, the declaration shall be disclosed to the public in a manner provided by law. Okay? This also includes a waiver authorizing the ombudsman or representatives to attain documents that may show assets, liabilities, net worth, business interests, and financial connections from all appropriate government agencies. All right? So, kailan ba kailan file SALN? No? So, it should be within 30 days after assumption of office, called entry SALN, or before April 30 of every year, thereafter called the annual SALN. And within 30 days, no, after separation from the service or the exit SALN. Now, what are the prohibitions, no, on use of SALN information? Okay, so 6713 provides that it cannot be SALN, no, the information in the SALN shall not be used, no, to obtain or use for any statement for any purpose contrary to morals or public policy, or for any commercial purpose, no, other than by news and communications media for dissemination to the general public. So, what are the offenses, no, in case that the public officer was not able to file his or her SALN? No? So, the law mentions that it should be a ground actually for administrative disciplinary action. No? So without prejudice also to file the necessary criminal and civil liability. So bigat din, nandun yung threefold liabilities. No? Okay? Then failure to file. What is someone failure to file? No? What should be done? Okay? Uh, by the government offices. No? So dapat merong compliance and show cause order needed, no? Before filing the complaint against the government official. No? So sometimes kasi the failure to file is maybe through inadvertence for that reason. No? So later I'll discuss in jurisprudence, no, the due process should be observed also for the government officials, and they should be given an opportunity to correct any wrong entries or to comply, no, with the filing of the SALN. Okay? So hindi naman dapat automatic na dapat parusahan agad because of failure to file SALN. Then what is this lifestyle check? No? So the law defines it as a fact-finding investigation conducted by government agencies to determine whether or not there is sufficient evidence to file a graft and corrupt case against an official who was acquired his wealth through corruption, no? Such as plunder or malversation of funds. So lifestyle check specifically deals with the question, is the public official's displayed lifestyle disproportionate, no, with his or her declared income? Right? So I think the office of the ombudsman, no, can conduct this lifestyle check. No? So even on the office of the president can also conduct such, no, for executive officers. Okay. Now we have this Republic Act 1379, no, for forfeiture of unexplained wealth act. So it declares the forfeiture in favor of the state of any property found to have been unlawfully acquired by any public official or employee. So Section 2 of the law mentions that whenever any public officer or employee is acquired during his incumbency an amount of property, no, which is manifestly out of proportion to his salary, as such, the public officer employee and to his lawful income and the income from legitimately acquired property, said property, no, shall be presumed prima facie to have been unlawfully acquired. So may presumption niya, no? Diba? Pag disproportionate yung assets, no, of government official with his or her salary. No? Okay. So, if a public official is observed to live a lifestyle or has acquired assets or wealth beyond his or her visible means of income, the wealth now is presumed to be ill-gotten. It's a presumption on law. And then the public official now has the burden, no, to prove that the assets were actually, no, legally obtained. Okay, now let's go to the plunder law. Republic Act 7080. So, what is plunder? No? Okay. So, in short, plunder, no, is direct or indirect amassing by a public official of at least, remember the threshold amount. No? Threshold amount is at least 50 million pesos. Okay. So, amassing, basically, diba? Obtaining illegal wealth amounting to at least 50 million pesos. So it's not just one taking, no, 50 million pesos. No? So plunder means that under the law, there must be a combination or a series of acts committed by the public official here. Right? So it could be misappropriating public funds. It could be through receipt of kickbacks, no, connection with government contracts, or illegal disposition of government assets. And all others, pwedeng through bribery, and all that, no? Malversation, bribery, right? And all of that combined, no? It accumulated around 50 million pesos, right? So the penalty for plunder is reclusion perpetua, 40 years imprisonment. Let's look at the other rulings on plunder. No? So the Supreme Court has declared that the law on plunder is valid law. No? It was questioned before. question for being vague, point for vagueness, no? But the Supreme Court declared that it's valid, no? Okay, because the High Court mentioned that the plunder law contains certain standards, well-defined parameters, no, which enables the accused to determine the nature of the violation. So the law is quite explicit, no, in describing the acts, conduct, no, the conditions required or forbidden, and prescribes the elements of the crime with reasonable certainty and particularity, di ba? So, sabi ng Supreme Court, very clear naman, no, yung plunder law, ano yung prohibit, ano yung pinapanis, di ba? So, actually, yun nga yun, di ba? It can be understood with little difficulty that what the statute punishes the act of a public officer amassing, accumulating ill-gotten wealth, no, at least 50 million pesos through a series or combination of acts enumerated, no, in the law, in the plunder law. Okay, so if there's nothing void about it, it's clear, no? The elements of the crime, no, it's clear. Okay, so in plunder, no, the Supreme Court also held that the established plunder not necessary to prove each and every criminal act done by the accused, no, in furtherance of the scheme or conspiracy to amass, accumulate, or acquire ill-gotten wealth, it being sufficient to establish beyond reasonable doubt a pattern, no, of overt or criminal acts indicative of the overall unlawful scheme or conspiracy. Okay, so not each act of illegally obtained wealth must be proven, no? Kailangan ma-establish is the pattern dito, no, of the scheme or the conspiracy, no, to acquire, accumulate ill-gotten wealth, no? Okay. So what's the prescriptive period of the crime of plunder? No? So it prescribes in 20 years. Okay. However, the right of the state to recover properties unlawfully acquired by public officers from them or from their nominees or transferees shall not be barred by prescription, laches, estobel. Alright, so the state, pwede lang bawiin talaga yung mga properties, no? It should not be covered, no, by prescription, laches, or estobel. And also, more importantly, the Supreme Court mentioned or stated that the plunder is a crime mala in se, no? Although it is a special law, okay, the Supreme Court is quite clear that it's mala in se because it requires proof of criminal intent. Okay, the intent here is to acquire, accumulate ill-gotten wealth. So that must be proven, the intent. Okay, the criminal intent, diba? Dolo, no? Okay, the intent to commit, to accumulate, acquire ill-gotten wealth in the amount of 50 billion pesos. Okay. Then there's this case of against GMA, no? That it also touched on the doctrine of command responsibility. Will it be applicable in a plunder case? No? So the Supreme Court held actually it does not. No? Okay. So it explained that the doctrine of command responsibility actually is limited. No, it cannot be applied in all instances. No? Okay. So it pertains only to responsibility of commanders for crimes committed by subordinate members of the armed forces or other persons subject to their control in terms of war or domestic conflict. So the doctrine on application civil actions for human rights abuse cases, which are not applicable in this case against the former president, GMA. No? Okay. Okay, so we'll also briefly mention the RPC provisions, no, that are applicable to public officers. So remember these violations, diba? Malfeasance and misfeasance in office. Also falsification documents by a public officer. Diba? Then there are frauds, illegal exactions, transactions. And also malversation of public funds or property. Take note, malversation, then it's also technical malversation. Right? Okay, so this pertains to accountable officers, no? Who were entrusted with money or property. They should hold this money and property accountable. No? Otherwise, they can be charged with malversation. Diba? And then there is infidelity also, public officer, that pertains to documents and even to custody, diba, of detention prisoners. And then there are other offenses, irregularities committed by public officers, which include disobedience, refusal of assistance, maltreatment of prisoners, prolongation, abandonment of duties and powers of public office, usurpation of powers, and unlawful appointments. Okay, so these are all the RPC provisions, no, on public officers. Okay, just take note of that and the special laws that we covered. All right, I hope you have gained something from that my discussion, no, on special laws concerning graft and corruption. Okay, so if you have any comments, can you can type it in the comment section. All right, so this is actually the last part of my lecture. No? We'll talk about cases, no? Supreme Court jurisprudential updates, no, on these anti-graft cases. No? Okay, so please comment. Yes, no, if you have learned something, no, from this lecture so far. Okay. Ayan, sige. Let's start with some cases. No? Ito sa case of Morales versus B9. No? This pertains to the condonation doctrine. No? So, I think all of you would know that the Aguinaldo doctrine, no, or the condonation doctrine, is already abandoned. Diba? Yung condonation doctrine. I mean to say, if a public officer was re-elected, di ba? Parang condonation na yun of the admin case against that public officer, no? Okay? So, but in this case, no, in Morales versus B9, no, Supreme Court already abandoned such doctrine. Diba? If you read this case, it was good by the Supreme Court. Kasi nga, yung condonation doctrine is really not a, yung principle of law. Wala naman daw basis. Dati, it was found upon parang US jurisprudence, no? But it's not, upon further review of such, it's not really applicable, no, to us. No? And then wala naman talagang legal basis for this condonation doctrine. Okay? So with that, the Supreme Court abandoned such, and officials seeking re-election can no longer invoke it to escape liability for administrative offenses committed during term. Okay, so abandon na itong Aguinaldo, or what you call the Aguinaldo case kasi ito, di ba? As promulgated before, or the condonation doctrine. No? So there's another case in Crebello, no, versus Ombudsman. Okay. So the abandonment of the doctrine of condonation, kailan na take effect to? No? So it is in April 12, 2016. No? Yan yung reckoning period dito. No? Okay. That is a time when the Supreme Court already denied the MR, no, in the case of Morales versus CA. No? Okay. So ibig sabihin yan, so after April 12, 2016, the public officers can no longer avail of this condonation doctrine. Okay? So, prospective application. In this case, the petitioner here, Carbello, can no longer avail of the condonation doctrine because although the complaint was instituted against him on January 9, 2015, no? Okay? He got re-elected on the following year, May 9, 2016. But it is within the prospective application of Carpio Morales the case, no? Kasi April 12, no? After April 12, no? Ito May 9, no? Okay? Hindi na pwedeng i-apply yung condonation doctrine. Okay? Then in this case of Madreo versus Byron, okay? So, and then reiterate na the defense of condonation, the condonation doctrine is no longer available, no? If the public official's re-election happens on or after April 12, 2016. Okay? The condonation doctrine covers re-election through regular and even recall elections. Ha? Take note, no? Okay? Diba? Hindi lang yung regular election. While recall election is defined as a mode of removal, the same could also operate as a re-election of the concerned incumbent public official, since it resorts to the democratic process of election to achieve its end, where the official sought to be recalled shall automatically be considered as duly registered candidate to the pertinent position, and like other candidates shall be entitled to be voted upon. Okay? So more importantly, like in a regular election, electorate in a recall election cast their votes to elect among the candidates who shall serve. No? Who shall serve them. So it mean to say it also covers, no, a recall election. Okay? All right. So tayo sa condonation doctrine. No? So let's look at another doctrine, yung inordinate delay, di ba? Yung delay that is whimsical, capricious delay, no? That it amounts to a violation of the right of the accused, di ba? To speedy trial and disposition of cases. All right? So ito sa Kagang versus Sandigan Bayan. So the ruling here, no? When will we count yung inordinate delay, no? So inordinate delay in the resolution and termination of preliminary investigation violates the accused's right to due process and speedy disposition of cases, and may result in the dismissal of the case against the accused. So paano pag yung kaso, like in the ombudsman, di ba? Merong fact-finding investigation pala. No? Okay? The ruling in Kagang is that the fact-finding investigation phase itself should not be included, no? Okay? In the computation of the delay. Okay, the burden of proving delay depends on where delay alleged, no, within the periods provided by law or procedural rules. So, pero yung fact-finding daw, yung fact-finding investigation itself, it should not be counted, no, in computing inordinate delay. Okay, so this was also ruled upon in Magante versus Sandigan Bayan. Okay, so a distinction was made between fact-finding investigations conducted before and after the filing of a formal complaint for the purpose of establishing the reckoning point for computing the start of delay. Okay? So, a distinction, no? Fact-finding and the filing of a complaint. So, in case if a formal complaint was initiated by a private complainant, the fact-finding investigation conducted by the ombudsman after the filing of the complaint is necessarily included in computing the aggregate period of the preliminary investigation. Right? Then, if the fact-finding investigation conducted before the filing of a formal complaint, as in investigations relating to anonymous complaints or motu proprio investigations by the ombudsman, it will not be counted, no, in determining the attendance delay. So during such fact-finding investigations and prior to the filing of a formal complaint, the party involved cannot yet invoke the right to speedy disposition of his case since he is not yet subjected to any adverse proceeding. All right. So in short, diba, when will that inordinate delay be counted, no, to constitute a violation of the right of the accused for speedy disposition of case? So it's upon the filing of a formal complaint and then yung preliminary investigation phase, no? Okay? Yung palang counted yon, no? Yung period na yon. So if the preliminary investigation took several years, di ba? Then the respondent here can question that, no? Inordinate delay, no? But however, if there is no formal complaint yet filed, it's only in the fact-finding phase, no? fact-finding investigation pa lang, no? There's no formal complaint instituted against the respondent, no? Maybe because ano pala, no? Meron ngang, for example daw, merong anonymous complaint or anything that should be acted upon, no? By the office in itself, no? That fact-finding investigation will not be counted, no? In determining if there is inordinate delay or not. So minsan, baka matagal yung fact-finding, di ba? Hindi pa rin covered daw yun. No? Kasi wala pa naman daw proceeding against the respondent here. Diba? Okay, so there is that period. No? Formal complaint or the other one, fact-finding before any formal complaint. Okay, this is clear. No? Okay. Then in the case of Revuelta versus people, it was issued last June 2019. No? So it actually applied Kagang ruling and also further expounded upon the Magante ruling. No? Okay. Pero dito, in this case, Supreme Court held that there was really no inordinate delay committed by the office of the Ombudsman that transgressed the petition right to a speedy disposition of his case. Okay. The office of the Ombudsman cannot be faulted for giving petitioner and his correspondents every opportunity to exhaust legal remedies afforded to them by law. So it must be emphasized that the state, no, like any other litigant, is also entitled to its day in court and to a reasonable opportunity to present its case. I mean to say lang, like in this case, medyo tumagal din yung kaso, okay, sa trial, sabi ng Supreme Court, Ombudsman cannot be faulted because there are several respondents and petitioners here and maraming filing of different pleading and all that. So that state, represented by the prosecutors in the Office of Ombudsman, must also be given opportunity to exhaust all its legal remedies, no? And to present its case in court. So, tumatagal, pero kahit matagal yung kaso, there is no fault on the part of the state. Dahil they're just exhausting all their available legal remedies and preparing to present all their evidence in court. Okay? Okay, now let's move on to ano naman tayo. Kanina, we already discussed about SALN, di ba? And we have already emphasized that it is important for public officials to submit their SALN. There is that importance because it is based on the Consti and RA 6713 and is further highlighted by this case, by Republic versus the former Chief Justice Sereno. That it was held by the Supreme Court that filing of SALN is a constitutional and statutory requirement. So it's very important because the failure to comply with such requirement may result not only in dismissal from public service but also in criminal liability. Okay, so I mentioned a while ago, diba? 6713 RA 6713 provides that non-compliance with this requirement is not only punishable by imprisonment or a fine, but it may also result disqualification to hold public office. Yun. Tapos, ito, in this case, diba, Chief Justice Sereno was not able to file her SALN while during the time she was teaching at the University of the Philippines. Ito yung, because of that, sabi ng Supreme Court, non-compliance with the SALN requirement, it also reflects on a person's integrity. It's not merely a trivial or formal requirement. Okay? So there is, again, emphasis on its importance and the mandatory nature. Then, former Chief Justice Sereno's failure to submit to the JBC her SALNs for several years means that her integrity was not established at the time of her application. So also affects integrity to hold office. Yan yung point dito sa case, di ba? Ni Chief Justice Sereno before, bawaran to. Okay? then failure to submit the required SAL-N means that the JBC and the public are divested, no, of the opportunity to consider the applicant's fitness or propensity to commit corruption or dishonesty. So as you can see from this case, again, no, it highlights the importance of filing of the SAL-N, no? Because dito, Chief Justice rin, no, was able to file her SAL-N. It was used against her, no, for removal from office, no, as the Chief Justice of the Supreme Court. Okay. Then there's this case also of Birago versus Martires, no, 2021 case. So ito naman yung ano, can anyone just no, go to the ombudsman and ask for the SAL-N of any public officer? Well, the Supreme Court held it's not, no? Okay. So while the right of access information to public officials SAL-N provided under the Consti and RA 691, the same is not an absolute vested right. So walang absolute right, no? Okay. So while no prohibition will stand against access to official records such as a SAL-N, the same is undoubtedly subject to regulation. So it can be regulated, no? Okay. The power to regulate the access by the public to this document stems from the inherent power of the custodian to control its very office to the end that damage to or loss of the records may be avoided. Okay? That undue interference with the duties of the custodian of the books and documents and other employees may be prevented. And that the right of other persons entitled to make inspection may be ensured. Okay? Thus, a custodian, such as the office of the ombudsman, no, it is not bound under every circumstance to allow or to grant the request of disclosure of a public official SAL-N to the public. Okay? A custodian is not prohibited by the Constitution to regulate such disclosure. Its duty, therefore, under the Constitution and applicable laws is far from being merely ministerial. Okay? So again, no, in short, hindi na pwede, anyone can just ask ombudsman, no, to release the SAL-N of any official. The Office of Ombudsman can regulate or disallow such, no, based on its own guidelines and rules. It's not ministerial, no? It's discretionary also upon the custodian of the record, which is the Office of the Ombudsman. Okay? And also, as a while ago, I also mentioned the prohibition, di ba, on the use of information of SAL-N, 6713, no? Under RA 6713. Okay? So, hindi yan absolute right. Okay? On anyone can just get the information on the SAL-N of any official. Right? Now, it's also held here in the case of Navarro, no? First Office of the Ombudsman. Okay? That the appropriate office or committee should have given here the public official the opportunity to correct the entries to conform to the prescribed requirements sa SAL-N. Okay? So again, RA 6713 and implementing rules provide that in the event of authorities that are determined that a statement is not properly filed, the appropriate committee shall inform the reporting individual and direct him to take the necessary corrective action. So this is what I mentioning a while ago, no, that due process was also be observed in case the public officer was not able to file a SAL-N or made apparently a wrong or improper entry, no, okay, hindi naman dapat kasuhan agad yung public officer, no. So the Supreme Court held that no, based on the law, dapat should the proper committee here shall inform, no, the public officer involved and must direct him to take the necessary correction. So, sabit ka ng corrected SAL-N. Okay? Kasi minsan, this happens maybe only through inadvertence or iba. The public officer is given the opportunity, no, to correct the entries in the SAL-N. No? Hindi lang pwedeng basta-basta. Agad-agad kasuhan din. Okay? Then in the case of the Department of Finance, no, RIPS versus Yambao, okay, 2019 case, so sa purpose daw of yung SAL-N, no? Of course, the purpose there is to defeat corruption. Okay, and then if providing opportunity again to correct a defect before being sanctioned is also aligned with this purpose of beating corruption. So, again, no, in this case, it was reiterated that to provide the government officer the opportunity, right, to correct any defects in the SACN before being charged with the case. Then, what is the prescriptive period, no, for SACN violations? Okay. So, the prescriptive period for violation RA 671 should be counted from the date of commission. Okay. Specifically, the date of filing of the SACN. Okay. So, of course, RA 6713 is a special law. The computation of prescriptive period for violation 671 is governed by Act 3326. In particular, Section 1C thereof, which provides an 8-year prescriptive period. Okay? Then, paano kung perjury? No? So, if you look at it, the prescriptive period, again, no, of perjury under the RPC is 10 years naman upon filing of the SACN. So, this is the prescriptive period for crimes punishable under the RPC, no? Based on Article 91, diba? From the time of discovery. Okay? So, in this case, however, discovery should be reckoned from the time of filing of the SACN. Okay? Time of filing. Because upon filing, perjury is deemed consummated. Okay? So, once the SACN is filed, it is subject to review, no, by the proper authorities. It is during the conduct of the review that errors or inaccuracies in the SACN may be determined. Okay? 10 years is more than enough time to discover any such errors or inaccuracies. So further, the date of filing as the date when the prescriptive period begins to run harmonizes also with the provisions of the RPC and Section 8 of 6713. So yan yung prescriptive period, no? Okay, perjury, 10 years from the filing, okay, of the SACN. Okay, maybe the last case I'll discuss, no, for today is ito, no, Section 3E of 3019, diba? Yung the case of Martel et al. Versus Bautista, no? Versus People, Bautista versus People, 2021 case, no? So this was asked during the last bar exams, no? Itong problem na ito, di ba? This case is a violation of a procurement law. So pag mayroon bang violation ng procurement law, does it mean that is already a violation of the anti-graft law? Matik ba yan, no? Especially 3E, no? Okay, 3E is, di ba, giving advantage to another or causing damage to the government, all right? But the Supreme Court held in this case, di ba, that violation of procurement laws does not ipso facto give rise to violation of RA 3019. Okay? So in order to successfully prosecute the accused under Section 3E of 3019, based on a violation of procurement laws, the prosecution cannot solely rely on the fact that the violation of procurement laws has been committed. Okay? Hindi lang porket mayroong lapse of procurement law, automatic na may pwede na kasuhan ng anti-graft law. The prosecution must prove beyond reasonable doubt that, first, the violation of procurement laws caused undue injury, no, to any party, including the government or any private party, unwarranted benefits, advantage, or preference. Okay? So, yung kasi elements, di ba, ng Section 3E, no, of 3019. And then secondly, the accused acted with evident bad faith, no, manifest partiality, or gross inexcusable negligence. Okay? So in this case, it was not found that there was such elements present. Meron lang na violate na procurement laws, no? Okay? Hindi ata, ito ata, hindi nag-bidding. Parang ganun, no? And then, but that does not automatically mean that there is a violation of 3019 Section 3E, no? Okay? These elements must be proven to be present. And then violations of 3019 must be grounded, no, on graft and corruption, no? Not mere violation of a procurement. No? Okay, that's the case of Martel. No? Okay. So take note of that. No? Kasi kumabas yan sa last bar exam. Alright? I think this is the last part of my lecture for today. So I thank everybody, no, for watching, staying until the end of this presentation. So again, no, please visit the VLC website at www.villasis.lawcenter.com to know more about the virtual law companion. So prepare for the bar examinations at any time, anywhere, and from any mobile device. So again, together we can. God bless us all. Thank you very much.
Walang natira video. Pag may natirang mitigating circumstance minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period, pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang epekto, maximum period. Offset rule, i-offset mo muna, tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, exception.
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are been controverted already. So maski walang reply, all matters raised in the answer are being controverted already. If you talk...
In relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay. But in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together we can.
natira, medium period. Pag may natirang mitigating circumstance, minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natira, medium period. Pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang epekto, maximum period. Offset rule, i-offset mo muna. Tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, exception.
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply, under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are been controverted already. So, maski walang reply, all matters raised in the answer are being controverted already. If you talk...
In relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay. But in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together, we can. Together, we can.
Walang natira, medium period. Pag may natirang mitigating circumstance, minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period. Pag may natirang mitigating circumstance, minimum period. So, gano'n lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang ang epekto, maximum period. Offset rule, i-offset mo muna. Tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, exception.
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are been controverted already. So maski walang reply, all matters raised in the answer are being controverted already. If you talk
In relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay. But in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together, we can. Together, we can.
Walang natira, medium period. Pag may natirang mitigating circumstance, minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period. Pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang ang epekto, maximum period. Offset rule, i-offset mo muna, tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, exception.
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply, under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are been controverted already. So, maski walang reply, all matters raised in the answer are being controverted already. If you talk...
In relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay. But in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together, we can. Together, we can.
Walang natira medium period. Pag may natirang mitigating circumstance minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natira, medium period. Pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang ang epekto, maximum period. Offset rule, i-offset mo muna, tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, exception.
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are been controverted already. So maski walang reply, all matters raised in the answer are being controverted already. If you talk
In relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay. But in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together, we can. Together, we can.
Walang natira video. Pag may natirang mitigating circumstance minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period, pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang epekto, maximum period. Offset rule, i-offset mo muna, tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, exception.
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are being controverted already. So maski walang reply, all matters raised in the answer are being controverted already. If you talk
In relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay. But in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together, we can. Together, we can.
Walang natira video. Pag may natirang mitigating circumstance minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period, pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang epekto, maximum period. Offset rule, i-offset mo muna. Tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, exception.
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are deemed controverted already. So maski walang reply, all matters raised in the answer are deemed controverted already. If you talk
In relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay. But in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together we can. Together we can.